This is the time and date for a hearing regarding a show cause regarding a alleged violation of an order from Judge Stutzman. And the matter is set for this morning. There are two files. I believe the one we're actually in, Mr. Thornton, is 25040CZ, the first case.
That's correct, but I scheduled a hearing and noticed a hearing on the default judgment in 533 also.
Yes, that was scheduled for today because we're all going to be here, and so that is the other case. Both are entitled Colon Township versus Alfred and Joanne Yoder. Are you Alfred Yoder?
Yes, sir.
And you're Joanne Yoder?
Yes, sir.
Mr. Lance Thornton is here on behalf of Colon Township. Before we begin, just a couple of matters. This matter was assigned to me after disqualification by Judge Stutzman, the circuit court judge. Some of the rulings that are at issue today have already been decided by another judge. The question is the compliance with that judge's order. So now I'm the judge that's hearing it. The township moved to disqualify me. I denied that motion, and so we're all here. Just as another aside, the matter is a public courtroom and people are welcome to be here, but you have to abide by the rules of decorum, and even if you don't respect me, you have to respect the process. So apparently Judge Stutzman had this same issue, but when I went to leave the courtroom, the bailiff called for all the people to rise, and everyone rose but one person. That's Mr. Andrew Brandt. So I asked the bailiff to remove him. He says he obeys the law of God, not necessarily the court, and I guess I respect that, but he can do it somewhere else. If he isn't going to rise in respect for the court, he's not welcome to be in here. So he can certainly watch the matter on the live stream. But I asked the bailiff to remove him, and apparently he agreed to that. I think the same issue arose in circuit court. All right. I had recommended sincerely that the defendants get counsel in this matter. They don't have to. There are some complicated issues here. There are some consequences of the findings. And it's my understanding, Mr. Yoder, that you don't wish to have an attorney here at this proceeding and you wish to represent yourself.
We're currently getting advice and guidance, but we do not have a formal attorney representing us in the court at this time.
All right. Ms. Yoder, you concur with that? All right. And my concern was that I don't think the advice and guidance you were getting was very good advice or guidance. You're of your own free will and you can make those decisions. All right.
Your Honor.
Yes.
Before the court proceeds to contempt, we respectfully challenge jurisdiction. Jurisdiction must be proven on record first.
All right. Your objection to challenge jurisdiction is denied. The court has jurisdiction. You reside in the state of Michigan. I reside in the state of Michigan. I'm duly elected by the electors of St. Joseph County, and I serve under the leadership of the Michigan Supreme Court. This is a constitutionally and statutorily created court. You're residents of Colon Township. Colon Township is the plaintiff in this matter. You're the defendant, and the court has jurisdiction. So that motion is denied. Anything else you want to say before we begin?
Yeah, Your Honor, we respectfully note our objection for the record and reserve all rights to appeal.
That's appropriate. And I'll note any objections you have to the ruling I just made or any other rulings. And you do have a right to appeal. The appeal from this level would be to the Michigan Court of Appeals. So I respect that. Mr. Thorne, do you wish to set out our roadmap here for this morning?
Yes, one of my first questions, Your Honor, was which matter do we want to start with?
The simpler one is the entry of the default, but let's start with a more difficult one, the contempt issue. That was what was originally set for today. Do you wish to speak to that?
Sure, Your Honor. If the court is ready, I would ready to call my first evidentiary witness.
All right. Why don't you make a brief opening statement to just lay it out for everyone that's here?
Okay. We find ourselves here this morning. Procedural history of this case was essentially there was a show cause hearing scheduled before Judge Stutzman in circuit court. I don't have the exact date of that, but the Mr. and Mrs. Yoder failed to appear for that show cause hearing after having been ordered to do so by the circuit court. Then we had another unscheduled hearing when the Yoders appeared at the court on a different matter. And I participated by Zoom, where it's my understanding that essentially the Yoders were arraigned on the civil contempt charge. And this hearing today was scheduled at that hearing to address the actual evidentiary hearing to determine whether the Yoders are in contempt, civil contempt of the court's default judgment and permanent injunction that entered in this matter on March 13 of 2025.
In civil contempt, you don't necessarily have a right to have an attorney to represent you. You certainly can hire one. There's not incarceration possible as a punishment for civil contempt. There is a fine of up to $7,500 and other equitable relief, meaning the court can order that certain things happen. But if you're found in contempt, you're not subject to incarceration, at least not for this hearing. And the burden of proof is lower in civil contempt than it is in criminal contempt. It's a burden of preponderance of evidence. But essentially, the allegation is the judge ordered back in March that you not do certain things and that you continue to do them. So the township ordered a show cause. You didn't appear for the show cause. There was a bench warrant. You came in and we took care of the bench warrants. And now you're here so we can proceed. All right. Thank you. Anything further?
No, Your Honor.
All right. The township may call their first witness.
That I would call Joanne Yoder, Your Honor.
Ms. Yoder, would you come up into the witness box? In civil contempt, you do not have a right to not testify. If you're charged in a criminal case, you have an absolute right not to testify. In a civil case, you don't have that right, and you're subject to being called by the opposing party. So, Ms. Yoder, would you come up here in the witness box, and then we'll see how we can proceed. Good morning. Would you state your name?
Joe.
All right, have a seat if you would. I know that Amish don't like to swear out an oath, so would you be willing to affirm that any testimony you will give here today will be truthful to the best of your knowledge and belief?
Under God, I testify.
All right, do you hereby affirm, not swear an oath, but affirm that any testimony you give here will be true to the best of your knowledge and belief?
Yes, sir.
All right. Affirm. All right, Mr. Thornton, you may inquire.
Mrs. Yoder, if you could try to speak up so that the proceedings are being recorded and so that I can also hear and everyone in the courtroom can hear your responses. Okay. Mrs. Yoder, where do you live? Where's your residence?
Yes?
I do have a problem with my mind does not work in groups of people. Is sometimes coming up with answers and to respond. So please excuse me if I cannot.
All right, well, let's see what we can do. Do you live in Colon Township?
Yes, Your Honor.
All right, do you live on Marsh Road?
Yes, Your Honor.
What's the number of the house?
30158. Actually, I have two addresses that I get lumps of two.
All right,
301001 and 30158.
30100.
Yes.
Okay. Thank you. And it's no fun to sit in a witness box. I've done it myself. I've had little small children in the witness box. But let's just try to do the best we can here.
In following up, Mrs. Yoder, with the two addresses you've confirmed on Marsh Road, the 30158 Marsh Road, is that your home that you actually reside in?
Yes.
And then the 30100 Marsh Road, that is a second structure on the same parcel as your home, is that correct?
Yes, Your
Uh, And that was built as a home, is that correct? That second structure?
Yes.
And those two, your home that you reside in and this second structure are on the same parcel of property, is that correct?
Repeat.
The two homes are on the same tax parcel? Okay. And you operate a birthing center in that second structure, is that correct?
No.
What happens in that second structure? Is it empty? Is it occupied? Who occupies it? Can you tell us a little bit about that?
It's a private ministry.
Okay. Can you elaborate on that? What do you mean by private ministry?
That's what we have as a private ministry.
Are there births occurring in that home?
It's a private ministry.
That's not my question. I'm asking you, do pregnant women give births in that second structure on that parcel?
My understanding, it doesn't matter what we do in our ministry.
Well, that may be your opinion. We'll determine that. Right now, we're just trying to establish what happens. And so you are required to answer the question.
That is part of it. But it's a private ministry.
So it would be accurate to say that the structure is used partly for pregnant women to reside there temporarily and give birth.
Yes.
With the assistance of a midwife.
Yes.
And this this birthing, the use of that structure for births, did you used to call that Mama's House Birth Center?
No, sir.
You never called it that?
No.
Did you have a name for it? Or do you have a name for it?
We did have, we did have
Okay. What's the name now?
Mama's House Ministry,
Okay. Was there a prior name?
Mama's House Birthing Center.
Okay. When did that change?
February 6th, when you had received all the documents of the change.
I missed it. February.
February 6th, 2025.
Okay.
And you received all that. We had given you the documents on that. That was recorded here at the courthouse.
Okay. My understanding, you had a DBA. Is that correct? Doing business as name?
Yes.
Okay. And so if I'm correct, it used to be before February 6, 2025, Mama's House Birthing Center.
Yes,
And then after February 6, 2025, you changed the name to Mama's House Ministry.
yes,
Has the important date here on my next few questions is going to be March 13 of this year, March 13 of 2025. Because that is the date that the default judgment and permanent injunction entered by the court. So let me start there. You did receive a copy of the default judgment and permanent injunction, correct?
I believe so.
And after that default judgment and permanent injunction entered on March 13, 2025, did you continue to allow pregnant women to temporarily reside at the 30100 Marsh Road for the purpose of giving birth to their child?
Yes, Your Honor.
Approximately how many births occur there in a week's time?
It varies.
What does it vary from? What would be the low? What would be the high?
What is the necessity of this?
Well, I'm interested too. I don't know if they're having one birth a month or 6 births a week. So I'm trying to get a sense of it. Bear in mind, I didn't start this case. Judge Stutzman's heard some things that I have not. So I'd like to know the answer to that myself.
Probably approximately between like 4 or 5 per week.
As an average. Would that be the case prior to March 13 of 2025?
Probably.
And would that be the case after March 13 of 2025?
Probably. Your Honor,
Yes?
may I speak for this before we go further?
Well, yes, what would you
So-
like to say?
The first court hearing, what he's talking about was all about Mama's House Burden Center. And there was, I've got proof here where that was all dissolved.
And so now it's Mama's House Ministry?
So that court hearing, what everything that we run through was all in default because there was no such thing.
I'll make a note of that.
Let me briefly respond, Your Honor.
Yes.
As part of this case, it's not the DBA that's the defendant, and it wouldn't be the DBA that would be the defendant. It's actually Alfred E. Yoder and Joanne Yoder individually as owners of the property that were made the defendants of this case and that were ordered not to allow the birthing center to continue on the property. So yeah, I guess it's the township's position that the change of DBA is irrelevant.
All right.
And Your Honor, then the next thing also. So we received paperwork on the hearing, and in that paperwork, there's nowhere that it gave us to shut down. It says as soon as convenient, and that's not an appropriate time because it was never convenient.
All right, well, we'll explore that.
So the births that have occurred and are still occurring out there after March 13, 2025, a midwife assists with those births. Is that correct? You have to verbalize your answer.
Yes.
Are some of the women giving birth there on the property we're talking about after March 13, 2025? Are some of them unrelated to you?
Yes. They're part of our ministry.
But they're not a blood relative or a relative by marriage.
Some are not.
Some are, some aren't.
Yes.
After March 13, 2025, are you charging the pregnant women that have birth there any fees for being allowed to use your property?
They donate.
They donate.
Some pay, some don't.
Do you have a established donation or a suggested donation?
Suggested.
Okay. What is that?
It's according to how much, I guess how long they stay.
Kind of based on length of stay.
So,
So is it like a room rental fee?
yes, Your Honor.
Do you have any other fees or suggested donations for the pregnant women that come there to have birth, such as maybe for meals or things like that?
No.
So that's included in the other donation you testified about.
No money for food.
I didn't catch that.
There's no money for food.
Okay. So the room rental you do accept.
Yes, Your Honor.
When there is a birth there, and again, I just want to concentrate now on after March 13, 2025. When there is a birth there, are you required to do any reporting as the owner of the property?
No.
So you're not required to report that a birth has occurred.
They have to have their documents for a birth certificate, that's all.
Okay, and that's what I'm referring to. So who prepares the documents that are necessary when a birth occurs on your property?
Midwives.
Okay. Do you have anything to do with that?
I have a midwife.
Okay. So would it be accurate to say you prepare some of those reports?
Yes, I do prepare some of the reports.
Okay. And where do those, and these are reports of the mother's name? Is that correct?
Yes,
The name given to the child,
yes.
the date of the birth, is that accurate?
is to fill out a birth worksheet.
Okay. So anything on that worksheet, you fill out or another midwife fills out, correct?
Yes.
Where do those reports then go?
Here.
Here, meaning to the courthouse? Would it be accurate to say they go to the county clerk's office here at the courthouse?
Yes.
And how often do you make those reports?
Just whenever we have a birth.
Within hours or days, how often after you have a birth do you make that report and submit it?
We aim to have it done within 5 days.
You deliver those reports to the courthouse by hand, in person, or do you mail them to the courthouse, or is it a combination?
Both.
Both? If I were to indicate that there's been approximately 87 births on your property that we've been discussing here, that has the two common addresses of 30158 and 30100 Marsh Road. If I were to say that there's been approximately 87 births since March 13 of 2025, would you think that would be roughly accurate?
I have no idea.
Does it sound way too low, way too high?
I guess I don't keep track. I don't know.
Can you tell the court why you are continuing to allow pregnant women to temporarily reside on your property and give birth to children in contradiction to the default judgment that entered in this case?
Well, number one thing, because the first court hearing was not appropriate. And number two, section 28, I've got the Michigan Constitution. I know you don't like it. You threw it in the trash. Section 28, right to productive freedom. Section 28, every individual has a fundamental right to reproductive freedom, which essentials the right to make and effectuate decisions about all matters relating to pregnancy, including but not limited to prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. An individual's right to reproductive freedom shall not be denied, burdened, or infringed upon unless justified by compelling state interest achieved by the least restrictive means. Notwithstanding the above, the state may regulate the provision of abortion care after fetal viability, and provided that in no circumstances shall the state prohibit an abortion that, in the professional judgment of an attending health care professional, is medically indicated to protect the life or physical or mental health of a pregnant individual. The state shall not discriminate in the protection or enforcement of this fundamental right. The state shall not penalize, persecute, or otherwise take adverse action against an individual based on their actual potential perceived or alleged pregnancy outcomes, including but not limited to miscarriage, stillborn, a birth, or abortion, nor shall the state penalize, prosecute, or otherwise take adverse action against someone for aiding or assisting a pregnant individual in exercising their right to reproductive freedom with their voluntary consent. For the purposes of this section, a state interest in compelling only if it is for the limited purpose of protecting the health of an individual seeking care, consistent with accepted clinical standards of practice and evidence-based medicine, and does not infringe on the individual's animus decision-making fetal viability means the point in pregnancy when, in the professional judgment of an attending health care professional and based on the particular facts of the case, there is a significant likelihood of the fetus sustained survival outside the uterus without the application of extraordinary medical measures. This section shall be self-executing, not provision of this section held invalid shall be servable from the remaining portion of this section.
The,
Michigan State Constitution.
and just to clarify, Mrs. Yoder, it's not that I don't like the Michigan Constitution or the US Constitution. I have a ton of respect for both. I just don't need to be provided a copy. I have copies of both and access to them. So
That
the,
is very appropriate.
so if I want to read you paragraph 3 of the default judgment. The defendants and their agents, servants, assigns, and successors in interest, and or anyone in active concert or participation with the Yoders with regard to the operation of the birthing center are permanently enjoined from operating a birthing center on the Yoder property. Do you feel you're violating that paragraph of the order by continuing to allow pregnant women to come there and have births?
No, I do not.
Has anything changed?
Let me stop you for a moment.
Okay.
Paragraph 2 precedes paragraph 3, but she brought this up. Paragraph 2 states, Colon Township's request for injunctive relief is granted, and the defendants shall cease operation of the birthing center on the Yoder property as soon as reasonably possible. I think that had to do with perhaps you had clients that were in the process and you didn't want to immediately close it to leave some of those women with no prenatal care and no option for birthing except as emergency basis. Well, that was March. It's now September. And what you stated earlier is it isn't reasonably possible or won't be. Is that part of your argument too, that it isn't as soon as reasonably possible as of March 13th? How do you interpret that? And bear in mind, this is before I got here. Judge Stutzman ordered, stop doing this. The request for injunctive relief is granted, meaning no more operation of a birthing center on that property. And you're to stop as soon as reasonably possible. And paragraph 3 makes that injunction permanent from operating a birthing center on that property. So there may be some interpretation about what is reasonably, as soon as reasonably possible. I'm sure it's somewhere between March 13th and September 24th. Do you know when the last child was born there? How recently did you have a birth?
Your Honor, we made an agreement and I followed the 10 Commandments.
Has there been a birth there in the month of September?
Because I don't remember the date that we was here. We made an agreement.
Agreement with God or with who?
to not have a birth there
All
until
right.
today.
Okay, so you don't right now know when the last birth was?
No, I did not.
Was it within the last 2 weeks?
Or whatever it was that we was here, that we made an agreement. That date was,
I'm not sure which date that is.
I think she was talking about the date of the unscheduled hearing
Okay, when they
when they were here at the courthouse and Your Honor
and
contacted
that
me.
was August 29th. So you're saying there haven't been any births since August 29th?
not there at that address.
Okay.
Just to follow up on Your Honor's questions, how long is the normal stay of a pregnant woman that comes there to have a child?
Not more than 3 days.
And how long before they actually come there do they normally contact you and make arrangements to stay?
Well, that can vary on how you are, what you're after as far as when they realize they're pregnant or when they're in labor. That can be 9 months, or are you considering on when they start labor?
I'm trying to get at, when do you schedule them to be at your property to give birth? How far in advance?
Well, they usually schedule with us like 8 months ahead, a lot of them, 7 or 8 months ahead. But as far as when they're coming in, you can't decide on that until they're starting to have signs, labor signs.
Until they would begin labor. Correct.
Yes,
All right, so when they find out they're pregnant, they'll make contact with you to get in connection with your agency or ministry, we'll call it.
actually, they don't contact me unless they're my patient. They contact the midwife, and the midwife lets them know.
All right, and then as you get closer to the date of birth, that's when they would come in.
Yes,
Sometimes you might not know till that day when they show up. Is that true?
yes.
All right.
Did anything change other than the name, your DBA name? And I'm talking, did anything change in the operation that you had there as far as the pregnant women coming to give birth? Did anything change after you changed the name to Mama's Ministry?
Yes, we have a donation, and also they sign an agreement to be a part of the ministry.
So prior to the name change, you were actually charging, not a donation, but an actual charge. Is that correct?
Yes,
So and after you changed the name, then you started accepting donations, if I'm understanding. I didn't catch that.
yes.
Do most women that use your property to give birth make a donation?
Most average.
What is there an average amount that they donate?
Probably on the average 400,
for their stay there.
yes.
I'm going to take a few moments here, Your Honor, and see if I can locate the date of the show cause hearing in front of Judge Stutzman.
Let's see if I got it.
I've got it.
All right.
In this case, Mrs. Yoder, we had a show cause hearing scheduled for July 2nd of this year at 9 a.m. And it was scheduled in the courtroom above us here in the same courthouse. Do you agree with that?
Said July 2nd.
Yes. The court had ordered you to appear to show cause why you should not be held in contempt.
Trying to think, because there was one of them that we made a mistake by not reading everything and found that after the court hearing, there wasn't even anything in my name. It was under, there was 2 forms we received. One was for Alfred F. Yoder and one was for Alfred E. Yoder, nothing for me.
Are you saying you weren't aware of the hearing?
I was aware of it afterward, but we did file special appearance forms. We had all of our information on there. You received it, you know. And the judge did too. There were special appearance forms here for you guys.
Are you saying you contacted the court and say, hey, I missed my show cause hearing, I need to reschedule? Is that what you're saying?
You have the information.
That's not my question. After you realized you missed the July 2nd, 2025 hearing, did you contact the court to let them know you missed it and you'd like to reschedule?
I turned in information here to give answers to questions because I cannot. I'm confused on which date's which.
Are you aware in the default judgment that entered against you and your husband that you were to pay some court costs to Colon Township? Were you aware of that?
Your Honor, can I answer that one for?
Well, we'll see whether she can answer it, and then perhaps we'll get the answer from you if we need it.
I know I did see something with that, but being as it was all, there was so many confused things and so many things illegally written and illegally done. And plus it being under Mama's House birth center and not even having something like that existing, it being a ministry, I feel it's all in default.
So it would be accurate to say you understood the court ordered you to pay some costs, you just decided not to pay them. Is that correct?
We paid something. I'm not sure. Was it that or what it was?
You each paid $1,000 cash bond, which is still being held. And I don't believe anything was paid other than that.
I guess otherwise I'm not aware of something else that wasn't.
You have no recollection of paying either my office or going to Colon Township to pay costs in the amount of $265.48. Is that accurate?
I guess I didn't realize that that's not what the $1,000 is about.
Well, it's not what the $1,000 was about. The $265.48 were taxable costs ordered in the default judgment for you and your husband to pay. That's all I have for Mrs. Yoder, Your Honor.
All right, Mr. Yoder, thank you. You've done fine. It's not fun, as I said, being here. Just a minute before you get up and go. Is there anything else you wanted to tell me?
I guess most of what I wanted to tell was, wanted to say, I'm kind of blank on it, but I know we turned in forms to give our speech. Made so that Lance has one and you have one.
All right, thank you. You can step down. This would be a good time to take a recess for everybody. We'll take about 10 minutes and we'll be back in a few. Stop the record. I will also stop the case in chief in this matter. Joanne Yoder has completed her testimony. Mr. Thornton, what's next?
I would call Alfred E. Yoder as my next witness, Your Honor.
Mr. Yoder, would you come forward, please? Good morning, sir. Are you Alfred E. Yoder?
Yes, sir.
All right, I'm going to do the same thing that I asked your wife. I know that you don't wish to swear, but will you affirm that any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I affirm.
All right. Thank you. Mr. Thornton?
Mr. Yoder, could you state your full name for the record, please?
Alfred E. Yoder.
And is it accurate that you also reside at 30158 Marsh Road, Colon, Michigan?
Yes, sir.
And that particular common address, 5-digit address, is to your home, is that correct?
Yes, sir.
And do you agree that 30100 Marsh Road, Colon, Michigan is the common address for the other structure on that property that was built as a home?
Yes, sir.
So those two homes and two addresses relate to the same property, is that correct?
Correct.
They're not separate individual parcels, correct?
Correct.
And I'm assuming you're aware, and let me start with this. I really want to concentrate on everything from March 13, 2025 forward, that being the date that the court entered the default judgment and permanent injunction. You understand that, correct?
Yeah, I know what you were trying to do, but like she said, there's no Mama's House Birthing Center in existence on that date. And that's who you were filing against.
So would it be accurate to say, because you reside there on a daily basis, correct?
Correct.
So you're aware that after March 13, 2025, your property there continued to be used by pregnant women to temporarily reside there and give birth, correct?
Correct. That is Mama's House Ministry running on a private contract.
Okay. But you're aware that it continued to be used under whatever name it was given at that time.
Correct.
Did you take any action to stop that type of activity?
No, because if you're running a ministry under a private contract, it's legal.
So under that explanation, you would continue to allow that property going forward to be used as a...
There has been no birth at that residence since I last talked with Middleton.
And that being towards the end of August?
Correct.
Of this year. You intend to resume births on that property?
Very good possibility, depending on what the outcome is.
Were you aware that you were to be in court for a show cause hearing on July 2nd of 2025?
I filed special appearance papers that you and the judge ignored.
So the answer to that
And
is
called sovereign gibberish.
okay. So the answer is yes, you were
Yes, sir.
aware that you were to be there.
I did appear with my paperwork on a special appearance, and you totally ignored it.
Okay. Were you there in person before Judge Stutzman on July 2nd,
Negative.
2025? Did you say negative?
Right,
Meaning no, you weren't?
right.
And were you aware that the default judgment and permanent injunction ordered you to pay Colon Township $265.48 in taxable costs?
No, because you were charging a business that doesn't even exist.
So would it be more accurate to say you were aware of it? You just didn't disagree. You disagreed that you owed it because of the way it was ordered?
The way I understood it, that is for Mama's House Birthing Center, and there's no Mama's House Birthing Center in existence anymore.
So you're not contending in any way, shape, or form that you actually paid Colon Township $265.48?
I did not pay them, no.
Do you have a role in the second structure on that property being used for pregnant women to come there and have births? I mean, do you regularly?
Honestly. I'm not starting seriously.
I'm
Well,
asking.
I mean, are you the park their cars, or do you clean the rooms, or do you mow the grass, or anything that helps the operation of the center?
The only time I appear there is if something breaks down and needs to be repaired.
Then you
Otherwise, no.
Okay. So it's primarily your wife that operates it, correct?
She takes care of the building, correct?
Okay. She's also a midwife, correct?
Correct.
So she also helps take care of the pregnant women that come there to give birth.
Correct.
That's all I had for Mr. Yoder, Your Honor.
Mr. Yoder, I'll give you the same opportunity as long as you're there. Is there anything else you'd like to say to me? All right, thank you, sir. You may step down.
My next witness, Your Honor, would be Rhonda Schwartz. Miller. Sorry.
Good morning. Do you swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief? All right. Also affirm, will you take a seat and state your name for the record, please?
Rhonda Miller,
How do you spell Rhonda?
RHONDA.
Thank you. Mr. Thornton?
Where are you employed?
County, St. Joseph County Courthouse, Clerk's Office,
Okay. What's your title?
Deputy Clerk.
Without going into all the duties of the county clerk's office, is one of the duties of the clerk's office to keep track of new childbirths
It is,
within St. Joseph County?
yes.
Do you have a role in that?
I do a lot of the home births.
Okay. Meaning you keep the records for the home births?
A lot of the home births we enter in by hand in the computer.
Okay. But you're the one within the county clerk's office that takes the information on home births?
I enjoy doing them, so I always volunteer for them. They're a little bit more work, but any of us can do it. But I like to do it, so I do it.
So you're the one within the office that primarily does it?
Yes.
Can you describe that process for us? Kind of when there's a new birth and you get the information on that, what happens?
Yeah, so if there is a home birth, there's some paperwork that we have to fill out to provide to the state. So it's usually like the midwife who fills it out. and they need to sign it to verify it. And then also like the attendant, like if there was a father on hand, he would also sign it, and it gives the weight, or gives the weight and the date that the child was born, their background a little bit. It's just kind of very information about the parents and about the child and where they were born.
Which is essentially on every birth certificate.
And what do you receive then from whoever was present at the birth that provides you the information? Is there a particular document you receive?
Yep, there's we have a form from the state that they provide, and that we give it to anybody. If they had a home birth, it has to be filled out. It's like a facility worksheet, and they just have to fill in the questions for us to provide for the state.
If I may approach you on.
Yes.
I put two documents in front of you. Can you describe each one?
Yep, the first one is the live birth certificate worksheet. It says a local registered state use only. So this is what like a midwife would fill out. Or if the mom or whoever has a home birth, they need to fill this part out. So this goes to the state. This information is always go to the state, and we give the state a copy also.
Okay.
And the second one is a facility worksheet for the live birth. This has things like where was the child born? It's just, and the father can fill this out, or also the midwife or whoever attended, who was at the birth, a neighbor, whoever was there attended. And they just have to verify that and fill out some information if they know the answers to this. Some of it's medical questions. So we also provide that for the state.
For each birth, do you receive both of those forms?
Yes. Mm-hmm.
So I'd ask that these be marked the plaintiff's exhibits 1 and 2 with the live birth worksheet being number 1 and the facility worksheet for live birth being number 2. So that's the first one.
All right, Mr. and Mrs. Yoder, these are simply the forms that the clerk has described that you use. Do you have any objection to those being admitted as an exhibit? Mr. Yoder expressed no, and that's number 2. No, wait a minute. I get it backwards. That's number 1. That's the live birth worksheet. And this facility worksheet is number 2. They are admitted.
So it's those 2 forms that your office takes in, the county clerk's office, correct?
That is correct.
And then what happens then? Once you receive those forms, what do you do?
So then we go onto our state website, and then we enter the information into them. And we also scan the forms into the state website, so they have the actual form themselves. So then from there, we can generate a birth certificate if we have all the information on the worksheets.
And the birth certificates are essentially private documents, correct?
Yes, very private.
You do not hand those out to the public.
That is correct.
They have a lot of private information in them.
Yes.
As part of preparation for today, I asked you to prepare a report. Is that correct?
Yes.
And more specifically, I asked you to prepare a report of how many birth records you had from Mama's House Birth Center and or Mama's House Ministry. Is that accurate?
Yes.
And the time period I gave you was from March 13 of 2025 through the most current you had. Is that correct?
Yes,
And did you prepare such a report?
yes.
And for the record, I'm going to hand the Yoders a copy of what I'm going to be handing Ms. Miller. Is that the report you prepared pursuant to my request?
Yes, we had, yes,
And essentially, it'd be more accurate to say I sent your office a subpoena for the records, correct?
yes.
Can you explain? I'm going to provide that so that the court can follow along the copy.
Thank you.
Can you explain what these are and I guess where you're starting? Because I've handed you a two-page document and a one-page document. Could you explain this report and how you produced it?
So the first one is the daily birth log that has the 2 pages to it. This is, we have to go onto the state website and run a report. We can run it from the date that you had suggested. It was 3/13 to 9/23 yesterday. And we have to put in like a range. It'll pull up from the address. I believe we ran it because at we had Mama's House and then we had Mama's House Ministry. So we had to run it with to get all the births of that time, we had to run it by the address, I believe.
So hence the 2 pages. The first page, would it be accurate to say, is it contains the address 30100 Marsh Road.
Yes,
And the second page contains an address of R002. I believe that has to do with rural route.
it was like R001 and then Marsh Road and then something after the address like that. So when they put it on, that was different how they worded it on the worksheet, like it was up.
But the births on this report, you have no question, are all originating from the Yoder's property on
Yes,
Marsh Road.
that's
Is that correct? And essentially the 30100 Marsh Road. That home with that address.
That is correct.
So what does this report tell us? How many births were there between March 13 of 2025 and today's date?
Yep, a total of 79. There was 75 in the first one and 4 on the next page.
Okay. And what is the third or the single page births per week it's titled?
Yep, so this one just gives, from that date also, we listed how many births there was per week that we received. And this one has 8 pending. So this one has 87 total because there was 8 that we had to return back that we were missing some information on. So we turned those back. So that would have been, we didn't get those to the state. So that way that says 87 instead of the 79.
So you're waiting for more up-to-date or more complete information before those get sent on to the state?
Yes.
Okay. So the births per week indicate how many births occurred at 30100 Marsh Road, Colon, Michigan, from March 13 on through today's date, correct?
Correct.
As reported on the forms that were admitted as exhibits 1 and 2.
Yes.
I'd move for admission of those as one exhibit, Your Honor, plaintiff's exhibit 3.
Mr. or Mrs. Yoder, do you have any objection to the admission of the clerk's report regarding the births? I would note there's no births reported after September 1. Oh, wait a minute. I guess possibly up to September 6th. The rest of September is 0 births. Hearing no objection, I'm going to have you mark this as exhibit number 3.
Does that mean the court has admitted it?
Yes. Thank you. Admitted.
Have you also, since March 13 of 2025, have you had any conversations directly with Joanne Yoder regarding the births that are occurring on her property?
I do. If I have a question, if something's not filled out correct on the worksheet, I call her. It's just short conversation. She'll answer the question, and yeah. So we probably had about 3
Okay.
within that time.
And does Joanne Yoder sign some of those worksheets that you get?
Yes.
Does she sign most of them?
Yes, whoever fills that out, they're the midwife of that. The reason they sign it, if they're unlicensed, they sign that. And so if she was there at that birth, then she would be the one signing that.
So it's accurate to say that each one of these 79 births represented on exhibit 3, your office received fill-out worksheets for all of those births.
There's some in there that was performed at the birthing center, but they're licensed midwives, so they do it through the computer. So we don't get, just a few of them are licensed midwives. They can already put it into the state. So we wouldn't get births on those if they're licensed midwives.
Okay, so those were, the information was given to you electronically, not on a paper.
Correct, electronically.
That's all I have, Your Honor, for Ms. Miller.
Is there a delay? For example, if we just pick a week, June 29th to July 5th, 3 births. Does that mean the children were born between those dates, or that's when the reports were filed?
No, that would be, I think this is the actual birth date.
All right.
The report runs by the birth date.
Okay. There were 2 births between August 31st and July or September 6th, and then none thereafter. Is that what the report shows?
Yes.
All right, thank you. Exhibit 3 is admitted. Do you either of you have any questions for Ms. Miller?
Negative.
All right, thank you. You may step down.
The next witness, Your Honor, I would call would be Joseph Klein.
Good morning, sir. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Please have a seat, state your name, and spell your first and last name.
First name is Forrest, F-O-R-E-S-T. Last name Klein, K-L-I-N-E. Most people in the court know me as Joe Klein. Middle name is Joseph.
Thank you.
Can you state your, do you have a position with Colon Township?
I do, I'm their zoning administrator.
And who's your direct employer?
Safe Bill.
Is it Safe Build Incorporated?
Yes,
It's a building code and municipal services company.
correct. Full service building company, yes.
And Safe Build has a contract with Colon Township
Correct.
to provide building code services and zoning administrator services and ordinance enforcement services. Is that correct?
That is correct.
How long have you been the zoning administrator?
6 years in June, I think it was.
Are you familiar with the Alfred and Joanne Yoder's properties on Marsh Road?
I am, yes.
Would that include 30158 Marsh Road and 30100 Marsh Road?
Correct, yes.
Have you been to those properties?
I have, yes.
Have you handled zoning permit requests for those properties?
I have, yes.
As part of your position as zoning administrator, have you been inside the structure home that has the common address of 30100 Marsh Road?
I have, yes, on one occasion.
Approximately when was that?
It was a few months ago.
And is it accurate to say that the Yoders allowed us to come and take a look at what was happening there at that address?
Yes, they did. They allowed us to come in the residence and spoke to us in the residence, yes.
As in preparation for today's hearing, I ask you to run what we commonly refer to as the fetch documents for the Yoder's properties. Is that correct?
That is correct.
Did you do that?
I did.
Approach, Your Honor.
Yes.
Are those, actually, I'm going to let you do it. How did you, are those the documents you produced pursuant to my request?
Those are, yes. I got on the St. Joe County Fetch's website, which is reflects records with parcel IDs and owner information, along with various other property information. And yes, I got on that website and printed these off this morning before work.
And how many reports are there?
There are 2 here.
And which parcels by parcel number are you, and when you give the parcel number, also give the common address that goes with that.
Okay. So parcel number 002-021-006-05, also known as 30158 Marsh Road. And I believe it's also 30100 Marsh Road as well.
That's the one, you've been here this morning, you've heard the testimony. That's the parcel with the 2 homes on it, essentially.
Correct, yes.
One being Mr. and Mrs. Yoder's residence, their home, and the other being the 30100 Marsh Road that's used as the birthing center.
Correct. My understanding is the birthing center is the west structure and their actual home is the east structure on that parcel.
There are other outbuildings on the parcel, but these are the 2 homes on that parcel.
Correct.
I do not have extra copies of those, Your Honor.
That's fine.
I thought it would be, so I can show them to the owners, but I would move for admissions of those as exhibits 4 and 5.
They're just public records in the county
Correct.
geographical system of all parcels. This is essentially an aerial picture of your house. Do you have any objection to that?
Negative.
I would ask that the O file be exhibit 4 and the 10 the exhibit 5. And I'm referring to the last 2 digits of the parcel.
Yes.
So 05 is.
That's exhibit 4.
Just for clarification purposes, and I can give you the exhibits back if you need them, the parcel number ending in 10, which one is that? That's not 30158 or 30100, correct?
Let me see if I have that.
Well, let me just give you the marked exhibit back.
I would have to confirm that.
Yeah, this is the one I'm talking about that ends in 2 digits. Of
That is
10.
correct. That is not correct.
So what is that of?
That is of a new parcel that was divided off the main parcel. I would have to look at the dates to see when that was done. It was sometime in the last, I think, 2 years or so. So that's its own separate parcel for a new structure.
So in short, that is the parcel, just for reference, that is the subject of the other case that
Correct.
Colin Township has with the Oders. That's case number 25-533-CZ.
That is correct. That is for that. Yes.
Okay.
All right, exhibits 4 and 5 are admitted. One describes the house of the Yoders and the building that houses the birthing center. One is a house just down the road, which houses a new structure that was under construction. Yes, Miss, just a minute. Miss Yoder, you have a question?
So the question Lance had for Joe about entering the 30100, that was against our will, very illegally done. But Attorney David Marvin was working with us. We had him helping us. And he knew that we wanted to work in peace. And so he said that he feels that if we let Lance come in and see for himself that this is all legal and everything is well taken care of, that we can work in peace. So that's the only reason we agreed, because we wanted to work in peace.
All right, this was,
We are still being harassed.
so this was in 2025,
Yes.
Negative.
2024.
No, this was before.
That would have been like December of 23.
All right, so at that time, David Marvin was the county prosecuting attorney.
It was right just before he moved up north.
I can confirm that I did have discussions with David Marvin about this matter. His official, he was communicating with me and corresponding with me. He officially said he wasn't formally representing the Yoders, but he was talking to them. Well, I would also state that any implication that Mr. Klein or myself, and I was there too, entered without permission or against their will is just inaccurate. We would have never entered under
Well, it
those
may be a matter of
circumstances.
perception, but obviously you weren't illegal entry. But Mr. Marvin was the county prosecuting attorney at the time this took place. He was county prosecuting attorney until December 31.
I would have to go back and look at that correspondence dates and those things. I don't believe so. I think he had finished by the time he started corresponding with me, and
So it
that's
would have been sometime after January 1.
to the best of my recollection, because I know he told me he was planning on moving up north at the time, and he was getting ready to move up north.
Well, he didn't come to work for the last couple of months. He wasn't here maybe in November or December.
Could have been during that period of time. I would have to check. the record.
Miss Yoder, you got some input on this?
July, I was in January
Was it January? All right, that'd been after his term ended.
last year.
Oh, January of 2024?
Think so.
Probably. This has been going on for a long time already.
All right, well. All right. I guess isn't crucial. I was just surprised that he would be, I didn't know if he was doing this in his role as county prosecutor or as advisory counsel, and whether he was still prosecutor or not. I guess it doesn't matter. But the point is, maybe you weren't real pleased about it, but under the advice of Mr. Marvin, you let them come in and inspect the premises.
Your
So,
Honor, sir,
yes,
like she said, we tried to work in peace, work
okay,
with a little bit of common sense with these guys, and you can see how far we've got.
We did hire David Marvin for an attorney.
all right.
But he moved out now.
Yes, he moved to Mason County, but I don't think he's there anymore. I'm not sure where he is now, but he's not here in our county. All right. So you paid him money to represent you? All right, let's proceed.
Mr. Klein, when is the last time you were out at the Marsh Road properties?
On the actual property itself,
No, just, or even driving by.
say it would be, it's probably been a few months since I've actually been by the property itself.
Okay.
I did ask an associate to go by there recently and verify some things for me from the road, but I have not been out there myself in a few months probably.
Okay. Is part of preparation for today, did you locate anything on social media to do with Mama's house?
I did look and see what was still floating around out there, and there is a main internet page that still says Mama's Birthing Center on it. When you open the link, it does take you to I believe it's Mama's Ministry, Mama's Birthing and Mama's Ministry or something along that line for a title.
Your Honor,
Yes,
that has nothing to do with us doing something like whoever's doing that. If someone's looking on social media, there's a lot of false things out there.
all right, so
As
you,
far as that, I don't even own a computer.
all right, so you don't run a
So I
website for your,
run nothing. I don't do no advertising whatsoever.
all right, thank you.
So whoever has that posted, I have no idea. It's not got anything to do with me.
Mr. Klein, did you run a screenshot of what you found, and where did you find it?
It was a local internet search, a Google search, and yeah, this was at 8:04 a.m. this morning that I located that. And then when I opened the link, it says Birth Ministries, Mama's House of Ministries, and then it just goes on with more literature and pictures of the inside of the building and whatnot.
move for admission to this as exhibit 6. Just based it just solely on the, but it's out there on social media.
Well, for what it's worth, I take Mrs. Yoder's under oath. She doesn't run this website. She doesn't even really know about it, but apparently it is on there. If somebody was to do a Google search, this is what they would find. So for that purpose, I'll allow it, and it's admitted as exhibit number 6.
Your Honor,
Yes?
is there a possible way we can find out who would have posted something like that?
Maybe somebody can. I'm not computer literate enough to do it. Facebook is
Deceiving thing.
I'm not on it, but it's a thing unto itself. For example, there is apparently a Judge Middleton Facebook page. I've never been to it. Somebody operates it, but I'm not really sure who it is. I don't look at it because I don't know. I don't want to know what people are saying about me.
I guess I can't see how that can be held against us.
Well, I'm not holding it against you. I'm just saying this is what would be found. For example, if somebody posts something on my Facebook page, I'm not responsible for it. Someone posted a picture. I didn't see it. My wife did, and Joan was very happy about it. A picture of me standing with another lady on the beach. I was wearing a winter coat. I had a picture taken with someone when I was walking down the street here in Centerville, and she photoshopped me and her on the beach in Florida or something, but I was never there with her. If I was in the beach in Florida, hopefully I wouldn't be wearing a winter coat. But anyway, yes, I'm not holding this against you. I'm simply noting that it exists. As far as I know, the people that go to my site are very kind. I don't go there myself.
That's all the questions I have for this witness, Your Honor.
All right. I have a couple. I'm late to the game here. There were a lot of things that were decided before I got here. And my first knowledge of this was when I saw a number of people at a county commission meeting the night we did our annual report, and they were expressing their support for Mama's House at the commissioners meeting, just in the public comment section. Before that, I didn't hear anything about it. Then I inherited it later. My understanding is the gist of this is not an action by the State Department of Public Health, any issue of licensing. The state of Michigan or the Attorney General has no involvement in this case. This is simply Colon Township's enforcement action. Is that correct?
That is accurate.
All right. And I don't know whether there ever was any, that's a question I've always had. Is there any sort of state licensing oversight here? But that isn't it. So the primary issue, or the couple, is one of the issues, Mr. Klein, that there are two houses on the same piece of property?
No, that is allowed in Colon Township under certain circumstances. I believe these meet that criteria. The problem is the zoning for the agricultural district doesn't allow for the use.
All right, that was my next question. In many townships, you can't put two houses on the same piece of property. You can't share a well, you can't share a septic system. Each one needs their own. So that's not one of the violations.
That is correct.
The crux of this is that portion of Colon Township is zoned agricultural, and this is not an agricultural use, so it's outside the zoned designation for this property.
Correct.
Which is what the whole thing rests on?
Primarily it's the use, yes. The use is just not allowed in that district.
Your Honor,
Yes, sir.
I'd like to have that somewhat explained, because Colin Township said you can't do it. No, I should say Lance Thornton said you can't do it. But if you go on the Colin Township map, and if you look for commercial businesses in the agricultural district, there's like 4 of them within 2 miles of them, and that's like 2 acres.
Okay, that may be true. That ship has sailed. Judge Stutzman made a ruling on this that said you can't do it anymore as of March 13th. That's where I've come into the game. I'm the zoning guy. You were at the hearing. At some point, the township didn't want me to handle this, and they asked me to be removed, and I denied it. I do zoning hearings in every village and township in the county. Each township or village may do things differently. And I see routinely where I am doing a zoning enforcement case, but I know that 2 miles down the road is a property that's even worse. And I'm not dealing with that property. I'm dealing with the one that's in front of me. So I don't know whether there are other non-conforming uses out in the township that aren't before me. All I know is this one was brought to Judge Stutzman. The township argued that this enterprise does not fit within the zoning description for this parcel, and they're asking to enjoin it. And he did. He said, you can't do it anymore. And then they contend that you continued to do it after he said, don't do it anymore. That's what we're here now. I've said more than once, you could have benefited, and you could benefit from legal counsel. Mr. Marvin was apparently in the picture for a bit. So once the default entered, you would have had an opportunity to move to set the default aside or ask for a rehearing. Those things weren't done. That was in March. So that order stands. Judge Stutzman in a circuit court order says you can't do it. And you can't do it apparently because the township does not allow this sort of enterprise in that agricultural district. It isn't done, at least under these purposes, because they allege that it's unsanitary or it's not properly set up with well and septic, or removal of medical waste, or any of those issues. It's simply, if your neighbor came and wanted to set a birthing center up across the street, the township would say you can't put a birthing center in that location. Apparently this has been here for a long time. There may have been some argument that it was grandfathered or preceded the zoning. I don't know about that. All I know is the order is in effect and it's not been set aside, and Judge Stutzman said you can't do it. And that's where we start. So you may have had defenses, but they weren't presented. And apparently they aren't saying you can't do this. You just can't do it there. I was surprised that there is not some sort of state licensing requirement, that if I wanted to start Jeff Middleton's birthing center in Park Township, I could put up a building and do it. I had naively assumed that there needed to be some sort of state licensing to do this. But babies have been born long before there was ever any township ordinance or before there were even hospitals. So some of your views on this, I understand where you're coming from, but they weren't ever properly raised and they weren't ever moved to set aside the order. So the order's in effect. And you have a right to appeal that to the Court of Appeals, but I think the time limit for that is probably passed, so you'd have to ask for leave. So you can't do this because Colon Township says you can't do this in an agricultural district. And Judge Stutzman agreed and entered an order that said you can't. Now, one of the things you cited in the Michigan Constitution is the governmental interest. And is there a compelling governmental interest to not put a birthing center in the middle of an agricultural district? And arguably the answer to that is yes. This property is about as much in the middle of nowhere as you can get to in St. Joseph County. It's not easily accessible to ambulance or fire service. It's got dirt roads. It's in the middle of corn country. St. Joe County is about 74% agricultural. About 74% of the land is farmland, and you're right in the middle of it. About 5% of it is surface water. So the roads and the rest of us live in the other 20%. I guess they're arguing this should be, if anywhere, in the other 20%. So anyway, I'm here to enforce Judge Stutzman's order of March 13th. And it's in effect whether you like it or I like it. That's the order. Mr. Thornton.
I have no other additional
All right.
questions for.
Excuse me, after I vented there. Mr. Or Mrs. Yoder, do you have any questions for Mr. Klein?
Yeah, he's sitting there as a witness. And from my understanding, from the FOIAs that have been filled out, he doesn't even have a valid oath of office. And if you look in the Attorney General letter, it is my opinion, therefore, that the city building inspectors and zoning enforcement personnel are not authorized by law to issue and serve occurrence tickets upon persons who violate the building code or zoning ordinance of a city. It is my further opinion that city building inspectors and zoning enforcement personnel may not be empowered to do so by city ordinance or further position. That was from the Attorney General.
That's an interesting piece of information. Again, that ship has sailed.
He's sitting there.
Oh, well, he certainly can testify. Some villages and townships actually appoint their zoning administrators. And I think what they probably did is appoint his company as the zoning administrator. But again, that ship sailed a long time ago.
If he's not carrying an oath of office, he's got no right to.
Well, you may have had a right to raise that objection some time ago, but the order's already entered. And you haven't moved to set it aside, and there's been no move to set aside the default. That hasn't been appealed. So that issue isn't before me. He issued you some citations. Now, very late in the game, you're raising this, which is one of the reasons why I have always believed you could have benefited from legitimate licensed legal counsel. Mr. Klein, you can step down. Thank you. Thank you.
My next and last witness for this matter is Teresa Owsley.
All right, just a minute. Are you guys good? Can we go on till noon? Do you need a recess?
No, Your Honor, I respectfully note our objection for the record and reserve all rights to appeal.
All right, I respect that. You've made your objection. It's noted for the record, and you reserve your right to appeal. Mrs. Yoder, do you need a recess? All right, then we'll continue. Thank you. Good morning. Please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief? I affirm. All right, thank you. Would you state your name for the record, please?
Teresa Owsley.
How do you spell Teresa?
Teresa.
And Owsley?
Owsley.
Thank you. Please have a seat.
This should be brief, Ms. Owsley. What's your, you have a position with Colin Township, correct?
I do, yes.
What is that position?
I am the township treasurer.
So as township treasurer, you keep track of what comes in and goes out as far as financial transactions for Colin Township. Is that correct? That's part of your duty. As part of preparation for today, I ask you to take a look at the township records. Is that correct?
Yes, it is.
Essentially from March 13, 2025 forward. Is that accurate?
Yes.
And I ask you to check those records to see if the Yoders had paid, or anybody had paid on the Yoders' behalf, the $265.48 in taxable costs ordered as part of the default judgment, correct?
Correct.
Did you do that? Did you take a
Yes,
look
I
at all
did.
the records?
I did, and I even searched by name, and there weren't no records saying that they had paid.
So as treasurer of Colin Township, you have no record that the Yoders nor anyone on their behalf have paid the $265.48 in taxable costs ordered in the judgment.
Correct.
That's all I have, Your Honor.
All right, thank you. And I think the Yoders confirm that. All right, thank you. You may step down.
That's all I have, Your Honor, for witnesses.
Your Honor,
Yes, sir.
if I'm not mistaken, that was another witness without a valid oath of office.
I don't know whether she has one or not. I think most
From the
township,
FOIA that were pulled, no.
well, she testified to something that you agree with. You didn't pay it.
But she was used as a witness.
Well, you don't need to have an oath of office to be sworn as a witness. If you're standing on a street corner and you're watching an accident occur, they can subpoena you to tell what you saw. Any layperson is entitled to testify to items within their knowledge. So although you can claim she doesn't have an oath of office, I do, by the way, and have had one for 46 years. All right, I'll note your objection on that as well. All right, no further testimony from the township.
That's correct, Your Honor.
All right, Mr. and Mrs. Yoder, the township has rested their case. You have an opportunity to tell me anything you want me to know. You don't have to. After we do this, we're going to take about a 10-minute break, and then he's going to argue. He's going to tell me what he wants me to do, and then you can respond to that in argument. Is there any other evidence you want me to have here this morning?
Negative, Your Honor.
All right, let's take a short recess. We'll come back at 11:15. The township will tell me what they're asking for, and then you can respond to that. All right, I'm gonna stop the live testimony portion of this hearing has been completed. Court's heard testimony under oath. We've received 6 exhibits, and I'm going to give each of the parties an opportunity now to argue what they think should happen. Mr. Thornton.
Yes, Your Honor, and my comments will be relatively brief. The Yoders made a decision to not participate essentially in this case when they should have participated in it and had the opportunity to participate in it and be heard. They then, after the court's default judgment and permanent injunction entered, and it's very clear that they were aware of that default judgment and permanent injunction. It was served upon them. They knew what it said. They then, because they disagreed with the decision, they intentionally kept violating the order. It is very obvious from March 13th through now and from the exhibit entered on the number of births out there, that the births could have stopped much sooner than they did. And I'm not sure from the testimony given by the Yoders that they intend to permanently stop them at this point, but I guess we'll see on that. My point is that the Yoders' contempt, and I think they are in contempt of Judge Stutzman's and this court's order, was intentional. And only from the township's persistence in getting to this hearing are we here today in almost the end of September. So the township is going to request a fine under MCL 600.1701. Actually 600.1715 of $3,500 per defendant to get the point across that the circuit court's orders are that and need to be followed or legally contested.
And pay the original $243. Now I have $2,000 of bond money, which I can allocate toward fines and costs.
Yes, we still want the $248 or whatever it was. And my understanding, the township gets none of that $7,000. So I would request, and the statute does provide for restitution to the township. I'm not prepared today to submit a detailed accounting of how much extra cost the township was imposed. I understand the township's not going to get its attorney's fees for the entire case, but it seems unfair to the township, to the missed hearings, the appearances I appeared for, the motion and order to show cause proceedings, the impromptu unscheduled hearing when the Yoders unexpectedly showed up at the courthouse, and then today's proceeding. I would like to request to the time to submit a request for the court's consideration to award restitution directly to the township for some of those extra fees and costs that they incurred.
That's generally called a bill of costs. As you know, I often, in fact, usually give any fine money to the township as restitution rather than keep it to the county. Zoning enforcement's expensive. If a policeman charges someone with a crime, with drunk driving, the county pays for the prosecutor, the county pays for the judge. It doesn't work that way for the townships. If the township proceeds to enforce an ordinance, the township pays for it. And if there's a lawsuit, there was a lawsuit in my township that cost the township about $25,000 in attorney fees, and they lost. So my practice is often to just give any court fine money that would go to the court to the township to offset the cost of the case. All right, so you're asking for $3,500 per defendant. The maximum would be $7,500, and that I allocate that as restitution. But we need a bill of costs and a further restitution hearing. All right, thank you.
And the 248.
And the 248. And as I indicated, I've got $2,000 in escrow from their cash bonds that they posted. All right, Mr. and Mrs. Yoder, their contention is that you violated Judge Stutzman's order by continuing to have births at your center. Now let's repeat. You changed the name of the enterprise from Mama's Birthing Center to Mama's Ministry. And it is a ministry. I guess I won't deny that. It's part of an overall worldview of things. But the ministry or Mama's Birthing Center wasn't charged. You were. It's in Alfred Yoder and Joanne Yoder's name. So as Mr. Thornton argued, that name change is irrelevant, but it isn't really that easy. People do that. They're sued on a debt. They owe somebody money, and they change the name of the company and say, well, I don't owe the money anymore. That company doesn't exist. Maybe that might work sometimes if there's a corporation or something. The other thing people will do is they'll transfer the property to somebody else for $1. Somebody's got a horrific toxic waste site, and the township pursues enforcement, and they transfer it to their granddaughter for $1 or something, and argue we don't own that property anymore. Sometimes we have to parse that out. At any rate, this action is against the two of you. Judge Stutzman ordered back in March that you not have any more births at that center in terms of a permanent injunction. Doesn't matter what the name of it is, you can't do this at that place. And you had births through April, May, June, July, September, and I'll take it at your word that there weren't any births after August 29th and none in September. Obviously, your place is, well, if we've had 87 births in 5 months, you're busier than some of the hospitals. I suspect there weren't 87 births at Sturgis or Three Rivers Hospital during that period of time. At any rate, they did present sufficient evidence that you've continued to have births there in violation of that order of March 13th. So I find that you are in contempt. They're asking for $3,500 to make the point. I think the point is going to be made with the cost to the township of doing this. So we will set a hearing regarding the sanction after you submit a bill of costs. My inclination is to reimburse the township for their costs. That may be enough of a sting. And as I said, I do have $2,000 that I can apply to the fine and the contempt. I do fine beyond the required standard. The township has established that you are in contempt for continuing to hold births through the summer at this facility. Now, let's talk about what happens next. He ordered that you can't do this there permanently. You don't agree with that and have not agreed with it, and you have a right to disagree with it. What you don't have the right to do is to continue to do it. If you continue to do it, they're going to file a petition for criminal contempt, in which case I can put you in jail for violation of the order. I could order under the equitable authority under the zoning law that the facility be torn down. I don't want to do that, and I don't want to put you in jail. I want you to stop. What you need to do, you obviously have a constituency. People like your service. I heard a number of people get up at the county commission meeting and say that we need this, we want this, and why is the government messing around with this? So you got people that want your service. You need to do it somewhere where you're allowed to do it. There are places that you could cite this that would not be in a zoning violation. The township says you can't do it here. That wasn't up to me. They filed the action. There was a hearing. Judge Stutzman made a ruling. Again, you had an opportunity to participate in your defense, but you didn't. So now we're all stuck with the order. You can't do this here. This isn't an order, but my recommendation is find some place where you can do it. And your followers will find you. We're gonna set a second hearing regarding the amount of the fine. And Mr. Thornton will provide a bill of costs. You'll have an opportunity to object to that. Then I'll make a ruling on how much the fine is. We can set that for Wednesday, October 15th at 1:30. Does that work for you?
It does, you said 1:30?
Yes. Mr. Thorne, I'd like you to do an order stating that the court found that the plaintiff had met their burden of proof and the defendants were found in contempt. And the court intends to order a civil fine or restitution. And they will set a hearing on the amount of that fine for Wednesday, October 15th at 1:30. All right, we now have to deal with the other case. Yes, Ms. Yoder?
For the Judge Stutzman hearing, I still feel that was very much, considering we had notified them, we had given them information about this is a private ministry, and being that would be totally out of their jurisdiction on doing anything like this against a private ministry. Before they made a court hearing, they had all this, and then Judge Stutzman lied about it. He said that we attempted to file our paperwork and we did not. We did, it's all proven fact, it's stamped, it's dated, it was done February 6th.
Well, you can appeal these. His ruling has been made and you did not move to set the ruling aside or appeal it. So it stands. If you had some defenses that could have been raised, they weren't. Now, a higher court, higher than me, may have a different view of it. So it's difficult to appeal a case to the Court of Appeals. I've done it, and you'd be very, very difficult for you to do this without legal counsel. And they're probably going to uphold his ruling. So if you want to continue your ministry, my suggestion is you find a place to do it where it conforms with the zoning regulations. Then you can continue with your ministry. Your clientele can still utilize your services, and you'll be in compliance with the law. All right, we have the preliminary injunction. We're going to shift the record here to the next case, which is file 25533CZ. That was the default judgment that entered. Request for default was filed by the clerk. What's the date of this? It's filed August 23rd of 2025. And I did a preliminary injunction order in that case, which I'm pleased that the Yoders have attempted to comply with that since my order of August 29th. The order that Judge Stutzman entered had a reasonable time in it. That time has passed. So the date is September 1st. And that date is passed, but there should be no further operation of Mama's House at this location after September 1st, 2025. So we're going to take out the reasonable time requirement. The people after that date have found other remedies. All right, let's shift to the new case, Mr. Thornton. That request for default was submitted. I haven't seen any response. What's your position regarding that?
Your Honor, I would like to call one witness, the township building official, to put on some brief testimony that would add a little bit to the admissions by the Yoders to the complaint, to each allegation in the complaint. And then I would request at that point, once that testimony is received, the entry of the proposed default judgment I submitted in this case.
Mr. Yoder, would you come forward again?
Actually, I don't.
I mean, Mr. Klein, I'm sorry.
Actually, it's Lance Bonifield.
Oh, all right. Mr. Bonifield, would you come forward? Good morning. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
And would you state your name?
Lance Bonifield,
Could you spell that for us?
LANCEBONIFIELD.
Mr. Thornton?
And you're employed by whom?
Safe Built.
And again, Safe Built has a contract with Colon Township, correct?
Yes.
To provide building code official services. Is that correct?
Inspections.
Inspections. Okay. And are you the present person that does that in Colon Township for
Yes.
Safe Built and Colon Township?
Yeah, I do plan reviews and in building inspection.
And are you familiar with the Alfred and Joanne Yoder's property commonly known as 30246 Marsh Road, Colon, Michigan?
Yes.
And this has a fairly recently built, quite large structure on it, correct?
Yes.
Approximately a 6,400 square foot structure.
Yeah.
And as part of preparation for today's hearing, I asked you to review Safe Built's entire file on this property. Is that correct?
Yes.
Did you do that?
Yes.
It's already established by the pleadings, the verified complaint and the failure to answer those allegations have been admitted that 2 stop work orders entered on this property. Is that your understanding?
Yes.
The first one entered on February 2nd of 2024. Is that correct?
Yes.
And the second one entered on April 8th of 2025. Is that
Yes.
correct? No, you didn't post those stop work orders. Somebody else with Safe Built did. Is that accurate?
Yes.
But you know that information from reviewing the file.
Yes.
Have, in your review of the file, can you tell us whether either of those stop work orders were ever rescinded or terminated by Safe Built or Colon Township?
No, they haven't been.
So they are still in place.
Yes.
Having reviewed Safe Built's file on this matter, can you tell the court whether building inspections have been conducted on the structure located at 30246 Marsh Road?
The only inspection performed there was footing inspection.
Should there have been other inspections performed?
Yes.
What is the kind of the status of that building?
Well, several inspections haven't been done, and I saw that when I went there. We should have had framing, insulation, whatever trade happening there, roofing and final. Those haven't been done.
Haven't been requested by the owners? So therefore, the structure has not been inspected.
Yes,
What state is
All right,
this?
let me start. That includes electrical, mechanical, plumbing inspections.
correct.
If we went out there today, what would we see? What status is that building in? How far along is it?
Final. It would be complete. Or the last time I was there was to post some documents on the door, and there was some siding that wasn't done and some site work that wasn't done.
But you viewed the inside of the structure through windows, is my
Yeah.
understanding?
And it's drywalled and the flooring is in complete.
And there is no and has been no building permit on this building for quite some time, correct?
Correct.
The former contractor that pulled the building permit terminated the permit, correct?
Yes.
In your opinion, or do you have an opinion as to whether this structure as built and as viewed by you the last time you were out there, is it built as a home or is it built as something else?
It looks like a healthcare facility to me. I opened up the drawings and looked at the floor plan. It looks like patient care rooms,
Is there a kitchen?
no kitchen. It's not in the drawings.
That's all I have, Your Honor. Again, that's in addition to all the verified allegations in the complaint that are considered admitted at this point.
Is there plumbing and bathrooms in the facility?
I'm not sure. I've never stepped into it.
Are they in the drawings?
I don't recall. All I looked at was the floor plan.
All right, thank you. Mr. or Mrs. Yoder, do you have any questions you wish to ask?
Yeah, I've got a little bit of a question on the affidavit for a search warrant. The affiant, or whatever they want to call it, is signed by Lance Bonifield. And from the FOIAs that were requested, he's got no valid oath of office. And if you go back to the Attorney General, he's got no right. It is my opinion, therefore, that the city building inspectors and zoning enforcement personnel are not authorized by law to issue or serve occurrence tickets upon persons who violate the building code or the zoning ordinance of a city. It is my further opinion that the city building inspectors and zoning enforcement personnel may not be empowered to do so by city ordinance or charter provision.
What's the name of that opinion?
That's an affidavit for a search warrant.
No, the Attorney General opinion you just quoted from.
Frank J. Kelly,
Yeah, but what's the name of the parties?
Delta County v. City of Gladstone, 305 Michigan, 50.8 NW 2D 908, 1943.
All right, county of, what county
And
is that?
on that same,
What county is that?
PA.
Delta County v.
All right.
City of Gladstone.
Also known as Happy Rock.
On the same affidavit for search warrant, it's a prosecuting official, Lance Thornton. I thought he's an attorney.
He
I
is,
think he's running two different deals on the same. And then if you go back to the search warrant,
And he doesn't have a legal oath of office either.
we've got the officer as Lance Bonifield. If he's got no oath of office, he's an officer. So I'd say that whole thing's null and void.
all right.
For the, I've got Motion here. I'd like to have, for you and Lance, to have one of these.
Yes, would you hand to the bailiff?
Yeah,
Yes.
if I could respond to what he said.
Well, you can ask him questions. We're not to the argument part yet, but if you have a question for him, you can ask it. Otherwise, I'll give you a chance to speak when we get there.
I'll just wait.
All right, this is, I'll get it date stamped by the clerk. I'll just put filed, bench filed. 9/24/25. I guess it's entitled Motion to
Dismiss
Dismiss.
for lack of jurisdiction in violation of constitutional rights.
Okay.
Introduction, defendant.
No, you don't need to read it all. I've got it here. Again, there's a timing issue. They filed this lawsuit. You had 21 days to respond. It did not respond.
We filed special appearance papers.
That's not an answer to the complaint. And then the time to answer has passed. So, all right, yes.
So, as far as the responding date, so we did start getting things together to respond within 21 days. And then we were served more papers on this all being changed from Judge Stutzman down to you. And there was no response timing on that form. That's why we brought a response on the date of the hearing with our special appearance forms.
Mr. Thorne, what's your response?
The court rules provide that once the defendants are in default, which they are, defaults have been entered against both Mr. and Mrs. Yoder for failure to respond with an answer to the complaint recognized by the Michigan court rules, that they no longer can participate in the defense of the action until that default is set aside, and that default has not been set aside. It's so I would object to any consideration of this motion filed here today. Is one, it's not a motion to set aside the default, and it's not been filed timely and was not served upon me and the township in time to respond to it. We can't be expected to respond to something we're given during the hearing. This case has been pending quite a long time also. The whole jurisdiction issue and this oaths of office, they've cited some of these arguments before. The statute they're relying upon, which is MCL 85.10-16, is Fourth Class City Act.
Yeah, the case that they were quoting from is a city case, not a township case.
And I believe the court's aware that there are different statutes and acts in Michigan that govern cities and townships. And I will represent as an officer of the court that the Fourth Class City Act does not have anything to do with Colon Township. The Michigan Constitution, Article 11, Section 1, really requires any official that is a legislative, executive, or judicial officer to be an oath of office. A building code official in the state of Michigan is not an officer either of the legislature, executive branch, or the judicial branch. And there is no state statute that I am aware of that requires a building code official to take an oath of office. And I know the Michigan Township Association backs that up.
Mr. Bonnefield, you can step down. I'll accept this for filing. We'll set it for a ruling. Again, I got it like 3 minutes ago. I haven't read it. I'll make a ruling on it on October 15th at 1:30. You may proceed with your motion for entry of a default.
Okay, Your Honor, based on our motion and the admissions in the verified complaint by having no answer filed, and the additional supplemental testimony given here by Lance Bonnefield today, I move for admission of the default judgment and permanent injunction that was submitted with the township's motion and brief in support of that motion.
I was looking for the order. As I indicated, these are circuit court pleadings and their on-base system is different than mine. Do you have a copy of that order with you?
I do, Your Honor. I have an extra copy of the default judgment.
I got a copy of the August 29th order.
And the orders were provided with that proposed judgment when they were served with the motion. It has not changed from that date.
I order, skip to the order part. It is hereby ordered the plaintiff's verified motion for entry of default dated September 12th, 2025 is granted. The above finding of facts are hereby incorporated and made a part of this judgment. The defendants and their officers, agents, servants, employees, attorneys, assigns, or successors in interest, or anyone involved in participation with the defendants are permanently adjoined from performing any further work on the interior or exterior of this building being constructed on the subject property unless a valid building permit is issued for the building by the building code officials and the stop work orders have been rescinded by plaintiff's building code officials. This is common. This happens all the time. The case right now when someone built a garage, and I don't know how well built it is, but they didn't get a permit. Or they build a house and don't get a permit. You'd be amazed how often that happens. At any rate, I order that. You're enjoined from occupying the building or allowing anyone else to occupy the building unless written authorization is obtained from the plaintiff's building code officials. If an occupancy permit is granted by the plaintiff using the building for anything other than a residential home for which zoning approval was obtained, this prohibits the use of the building by midwives and or pregnant women as a place to give birth in return for compensation, including room rental fees. This does not prohibit a woman from choosing to have a home birth in the building if that building is that woman's principal or permanent residence. Plaintiffs I'm gonna put in here rental room or fees or donation. Plaintiff shall cause a certified copy of this judgment to be recorded in the Officer of Register of Deeds for St. Joseph County within 30 days of the date of the entry of this judgment. No money damages are awarded to Colon Township. Defendants are ordered to pay $304.38 in taxable costs in relation to this motion. They shall be paid within 30 days from the entry of this judgment. The permanent injunctive relief granted in this judgment supersedes the previous injunctive relief granted in the preliminary injunction order dated August 29th. The court retains jurisdiction of the case to enforce the terms of this judgment. From what I saw, that looks like a nice building, and it does look like a medical facility. I'm sure it could be used for something, but it can't be used for a birthing center. I'm going to accept this filing and this filing. I'll ask that the clerk date stamp these and provide a copy of this permanent injunction to the defendants. You have a right to appeal this, but there's a process that is to be followed. This one's a thornier issue. My recommendation is you simply continue your ministry at a different location. A lot of money was spent building this building without a proper permit and without inspections. And we had a case several years ago where a church, they did a large bunch of construction without inspections or permits. They got the girders up to support the church and they didn't match. It was a big mess, and eventually it was rectified, but nowhere in the county can you do this, build a building without permits and inspections. So that's my order. I would ask you to go up to the, unless you want me to just mail it to you, I'd prefer to give you a copy today. Could you guys process this and bring a copy back down for the defendants? All right, you give those to us.
Your Honor,
Yes, Ms. Yoder?
I would like to reappeal both cases.
All right, you can do that, but you can't do it by saying I appeal. Any more than you can say I divorced you 3 times and be divorced. You have a process you have to follow. All right, Mr. Yoder?
Just for the record, I guess, so you know, we had a building permit, we had a foundation permit, we had a zoning permit, a well permit, a septic permit, mechanical permit, and a plumbing permit.
Well, that was my understanding that it started out, it was
Now,
permitted.
why, if they give me the permits, they had the prints that they could see exactly what that building is. They knew exactly what the square footage is of that building because it's right on the permit. I've still got copies of the permit. Once the building is all built, they say you can't do that. The thing of it is, mister, when we got to the point, my wife says, we got to do something different. She's going to need a new building. I says, all right, you go up, you find out what we need. Because the only place I can put a new building is in 2 acres of woods. So I'm going to have to clear 2 acres of my woods so my wife can put a house in there. I says, I'm not clearing woods before we've got permits. Ain't happening. So they give us all these permits. She talked with Joe from Safe Built and told him what she wants to do. And he told her how to fill out the permits. Okay, so we had the permits. The building is all enclosed. Yes, it's not going to weather from the outside. But all of a sudden they said, oh, you can't do that because you need this and this and this and this. Explain that.
I don't know that I have an explanation. I agree. This was started. You didn't just show up in the dark of night.
It's totally uncalled for.
All right. The problem is they filed the action, the default entered, And now you raise your defense.
We filed personal or special appearance papers on every court case
All
that
right,
was filed.
so you have this concept of oath of office and special appearance papers. The court didn't accept those as a pleading. As again, you need legal help, real legal help, somebody with a license and some understanding. And I would encourage you to continue to get it. You've got a not what looks like the bones of a very nice building there, but you can't use it for the intended purpose. And you're right. They let you start this, and then somewhere along the line, the wheels fell off.
Well, how can they do that?
I don't know, but they just did.
Your
So,
Honor.
all right, we're going to be in recess. This matter is completed. You wait here. They'll bring you a copy of the order. You have a right to appeal it. We're going to have a further hearing on October 15th, where we'll determine what the penalty is, and I'll have an opportunity to review your motion and rule on it. If you want to file anything else, you can file it and schedule for hearing on that date. All right, we'll be in recess. Thank you all for being here. This is a public proceeding, and it's a healthy thing that people can actually